I don't think we're okay. Now we're live.
We're live now. All right, we are live. So you guys watch and you get what you get. This is not CNN or Fox. So welcome everybody to this week's edition of the John and Steven Show, more professionally known as Legal Ease, where we make it easy for you to tune in and find out some information about what's going on the legal world with credit repair. John Watts, my co-host here with. Man, you've got an amazing YouTube channel. You'd almost make me jealous, but I'm not a jealous kind of a person. How are you doing today, John? What's going on in your world, sir?
I'm doing good, man. Doing good. So good to see you, and appreciate you guys taking care of things a couple of weeks ago when I was facing some massive storms.
It was the Shiva and Steven show that week, and I got to tell you, I think he got a lot more love than you did. But we're going to show him up. We can catch up this week. So.
He deserves it. So
yes, indeed. So,
hey, let me ask you this, because we were talking before we went live about the software program that you're coming up with, and I was harassing you about that and trying to get an update out of you. So why don't you share, maybe give people sort of a quick overview, and then what's the timetable look like?
Sure. Well, unlike a human baby, where the gestation period is almost exactly 9 months. When you're birthing a brand new cloud-based software system from scratch, you don't exactly know how long it's going to take to have that baby. But we are getting close. We're in the final stages of getting it kind of deployed online. There's a few more things we've got to finish up just as far as features for the beta. But it's Palmieri system beta is what's coming out, and it's the first pre-litigation software in the marketplace. And what we mean by that is it's the first software that'll pull in your credit, actually let you audit the data from all three bureaus against each other, which is really against their one industry standard, which is Metro 2, because all bureaus use one standard, which is Metro 2. And then you can generate those letters. Some people call it factual letters, but with the actual credit data from all three bureaus for your trade line in one letter. Because again, if you're auditing Capital One, you want to put everybody on notice of all the errors, because again, they all use one standard. So it's going to be the first pre-litigation software in the market. We're getting close, John. I know you've been patiently waiting, my friend, and so we are coming out soon. If anybody has any questions, feel free to shoot me a message, or Steven at stevenpalmieri.com, and send me an email. Would love to talk to you guys.
Well, good. That's I know a lot of credit repair organizations are waiting for that, and what I've seen so far has been very good.
And attorneys, I might add, like yourself. It's interesting. We've got credit repair companies and attorneys. And one thing, I know we've talked. Right now, we're going to pull in a couple of your popular credit monitoring companies. And then for you, for a lawyer, I can appreciate you. You're like, that really is of no value, because we can't litigate from credit monitoring. We need to use the bureau direct data, which would be like either the portals or annual credit report. And we will be working on where we can actually pull in that annual credit report data, not out of the initial release, but we will be getting there. So we've actually had some pretty good feedback from the legal community as well on what it's going to be able to do.
Yeah, that's the big thing. For us, the lawyers that are filing lawsuits, we really need the actual credit reports from the bureaus. And I mean, what you have right now is very useful, and that will just take it to the next level. So I don't know why I have you on this show. I should be making you go code or something, but you don't know how to code, do you?
No, they've got that little thing, #learn-to-code. That's designed for me. I don't know how to code, but I've got some really smart, motivated, excited people that are part of the team, and so we've just got a good team here. So we'll get there. And obviously, for those who are watching, if you guys have questions, feel free to post them up. I see Sherry Gonzalez. She says, hey. Let's see here. Sherry says that's me, the legal community. So yeah, post in your questions. That's what we're here for. Sherry, you got any questions for Ask the Attorney? You are here. We've got your full attention right now. So let us know what's on your mind. But I don't know. While we're waiting for questions to pop in, John, since we're kind of talking about the software and pre-litigation, I mean, let's maybe talk a little bit about that. I mean, what do you look for from the legal perspective, right? I mean, because we were talking before the show that credit monitoring reports are all good just to kind of see what's going on, but you can't litigate on those. Why don't you kind of share with folks kind of why that is?
Well, when we're suing, and I'm talking about specifically suing the credit bureaus or furnishers of information like Capital One, Midland Credit, those types of guys. If we're basing it on the credit reports, the great defense they have is, well, that's not what the credit report says. You have what Smart Credit says or Identity IQ, but not what the actual reports say. And that's pretty devastating. So, in my world,
They've got the he did it, she did it. It's not me. It's them, right?
So now there are ways around it. I mean, if you have a credit monitoring, and then you do good disputes, and then you get the results back from the bureaus. But Stephen, one thing that I've noticed from talking to a lot of folks in the credit repair world is they'll send me the Smart Credit and then the dispute letter and then another Smart Credit. I say, where are the results of investigation? They go, oh, we can't get those from people. People won't send them to us. And I'm like, well, we have to have that. Okay. And so one thing that I do is just on cell phone, Adobe Scan. I don't have any connection with it other than I like it. It's very good. It's free scanning app. And, we get our clients to do that. So when they get the results of investigation in the mail, they scan it. And that way, at least you now have some true data from the bureaus. And so we're looking for actual errors that have been identified. And that's why I'm interested in your software, because everything I've seen on the market is just really no good for this. I need the actual errors to be identified to the credit bureaus. I was doing a webinar this morning, taking some folks through sort of a step-by-step process, how to get your reports, dispute, read the results of investigation so that it's set up to sue. And one thing I was pointing out is people will do these disputes where they say, I understand Capital One has an account associated with my Social Security number. Please verify this account for all errors. I'm like, what is that? Oh, that's my dispute letter. I'm like, no, that's nothing. That is absolutely, like if I brought that lawsuit and said, Judge, here's my dispute letter, something about my Social Security number, and verify, Judge is going to be like, Mr. Watts, we need to talk about sanctions.
Mr. Watts, looks like you just found yourself a summary judgment against you.
Yeah, so not a good situation. So we want to be very, very specific. And so whether you do this manually, whether you do it through software, we've got to have, good stuff there. So
yeah,
let me see here what we've got. Ray Rogers says, Stephen, how do we become part of your credit repair company coaching program?
Yeah, sure, Ray. So, I mean, you can sign up directly online, creditrepairtrainingcourse.com. Creditrepairtrainingcourse.com will bring you right there. And then I'll reach out to you and get you onboarded. If you want to talk first, absolutely. You can just email me, Stephen@StephenPalmieri.com. You can shoot me a text, 817-228-0491. Smoke signals as well, but I may not get those. But yeah, any one of those ways, man, would love to talk to you and have you on board. I appreciate you for asking.
All right. So let's see, Stephen, you tell me, did I get your email address right on there?
Dude, you're getting good with those Italian last names. Yes, you did.
All right. Well, very good. Very good. So, yeah, Ray, just get with Stephen on that. He'll be glad to talk to you. Let's see. Rick says, video is very nice education. Okay. Well, thank you, Rick. That's we've got a webinar series going that, there's no cost for it for people that are interested. Let's see. Well, we're glad to have you. We're glad you made it, Miss Michelle. And just let us know if you have any questions. Let's see. Terrence says, I filed a complaint with CFPB with attachments identifying errors. CFPB sent the complaint to TransUnion. They initiated a dispute. Can I sue TransUnion if they verify as accurate? So it's a very, very good question, Terrence. And I don't know that there is an absolute answer. I'll give you my answer, which is I would be concerned about suing on that because you did not do that dispute directly to TransUnion. You said
I was going to say the same thing, actually. We were thinking the same thing. They're not going to like the answer, but if I were defending that on the bureau's level, because a CFPB complaint is an entirely separate part of the FCRA, right? So I was thinking the same thing you were, John, but go ahead.
Yeah, and look, there are people that take that approach though, and they fax to the CFPB, and then the CFPB takes it to TransUnion. The way I look at it, you're taking a chance at any stage of that litigation. A judge could look at it and say, actually that wasn't a dispute to the Bureau. And the way you solve that is you spend about $8 on certified mail and you send it to that. So, if you have a case that's worth $1,000 or $10,000 or $75,000, I don't want to risk that over $8 or $10 for certified mail. So that would be, my thought on it. And let's see, Muriel asks, do you do credit repair as well? So I'll answer that. For my own clients, we'll help them dispute things, but primarily what my firm does is we file lawsuits when errors do not get fixed after they're properly disputed. Now, Stephen, at least at one time, had an actual credit repair company. Do you still take notes?
Sure, absolutely. Yeah, I mean, if you want to reach out to me, I'd be happy to work with you. So what John is trying to say is kind of like, when the average person goes out to go fishing, they kind of like, they put the little piece of bait on the hook and they go out with the hook and they kind of wait for it. When John goes fishing, he goes out with the C4 and the explosives and just dynamites the entire lake. So he does credit repair and he does it through litigation, But yeah, no, I mean, you can reach out to me again, Stephen at stephenpalmieri.com. Happy to talk to you and we can work with you or refer you to somebody in a state where you may be if it's not something that we can directly work on.
So we have a Facebook user. I'm not sure exactly who that is. Stephen may be able to figure it out.
Warren Maxwell.
Is that Warren? Okay. Well, good to see you, Warren, AKA Facebook user. And I think that's my StreamYard is like protecting everybody's privacy or something. But it's a great question. Can you call the collector and dispute over the phone to get an E8 violation? So this is talking about a section 1692 E8. That's where you dispute to the debt collector, then they update your report, but they don't mark it as disputed. And the answer is absolutely. You can do that over the phone. So verbal, by letter, maybe even by smoke signals.
I mean, I was going to say now with all the rules and stuff that the CFPB has on the debt collectors, you could probably send them a little social media note that you disputed. Because John, isn't it right that CFPB, they've kind of now said that debt collectors can reach out to consumers via social media, right? Something like that?
So that's a very interesting question. So they changed the rules effective this coming November 30th, but they now are saying that the CFPB is saying, well, now we think we need to give collectors more time. We think this is too hard for them. And so we want to postpone these rules till 2022. And so much for everybody who dreamed that the Biden administration would be consumer friendly. You can look at his record as a senator and know that
where his donors are, right? Just like all politicians.
Yeah, he is Mr. Credit Card Company. But in any event, probably it will be delayed. But whenever those new rules go in, they can, send you a Facebook Messenger, direct message on Instagram, text message, all that sort of stuff. So you can really, if they reach out to you in one way, like a Facebook message, you can respond in that way, which the collectors absolutely hate that because they're like, no, that's just for us. You should have to send us a certified mail, but we can reach out to you. And, that's cute the way that they're, crying about it.
And they play a valuable role in the marketplace to recover billions of dollars a year in bad debt.
I'm sure they do. So, all right, Clyde says, I dispute an account that's closed. Say I have a $40 payment, but the account closed. So I'm not exactly sure if you're saying that it shows a $40 monthly payment due.
I think she's saying that the account's showing as closed, but there's a $40 either payment due or balance.
Okay.
If you've got an account that's closed, like a credit card, it could be closed for further activity, but you still owe like a balance. So Yeah, no, we have seen it sometimes where you kind of like you've got no balance, but then maybe you make the last payment a couple days too late, not 30 days late, but like maybe 3 days too late, and it hits you with a late fee. But so it's not necessarily an error if there's a balance and it's closed, unless you're saying like literally you don't owe them any money. Then that you would want to kind of figure that out, I would say.
Yeah, so definitely look and just see if there's some kind of technicality there that, maybe it was a late fee or an annual fee or something that popped up. And um, let's see, we have Muriel say a huge thank you. Well, you are very welcome.
We
And
love you too, Muriel. We love our support family.
and so definitely, any questions anybody has, put those up. So let's see, we have Lawyer by Day here. Is this a lawsuit? Client settled an account for less than what was owed. Equifax and Experian both state the account is paid and closed, but they also state in the payment status it's over 120 days past due. So it's a great question. Sometimes this is called a status case, or there's a case name from a few years back that sometimes people describe these as. The basic idea is the payment status should not be 120 days late if it's been paid off. Okay. It should say closed or settle for less than full balance, but it should not say 120 days late, because that makes it look like, if I'm trying to get credit and I go to Steven and he pulls my credit report and it says over 120 days late on the payment status, it looks like I owe them money. But in your example, they had paid off the debt. Maybe it was $3,000. They paid $2,000. Well, as long as the creditor or the debt collector accepted that, then they owe zero. In the payment status, now it could say was 120 days late or previously over 120 days late, but now closed. And so I would definitely dispute that. And if it doesn't get fixed, then I would look at filing suit. What do you think about that, Stephen?
So, I mean, it's kind of like I'm a little conflicted here because I know there's these precedents about the status, but I mean, and part of it may be that it's one of these reports that's not giving really good data, because with Metro 2, it's going to show you the status that it was when it was as of the most recent status. And so, like you had said, you put the word was in there, which is really important. So if it says, closed was 120 days past due, then that's okay because it's showing you when it was closed. It was 120 days past due. But so I guess my question would be: is that coming from a bureau direct credit report, or is that coming from a monitoring? Because a lot of times those monitorings aren't really good. But then to John's point, there's also case laws and stuff where, so I wouldn't say it's black and white, but if it does show that it was 120 days past due and it's currently closed, I don't really think there's actually an error with how that would be reporting.
Yeah, so that would be the question, what do the actual reports say? What do the results of investigation say? And then particularly we can pull from annualcreditreport.com once a week for free. I just have my clients continually pull those. And so if it's saying that it is 120 days late, and we're not trying to, nitpick too much on this, but it says it is over 120 days past due, that's a problem. Now, again, if it's historical, then that's fine. But, so you say here that it was disputed, they didn't change it. So, yeah, I think it's misleading unless it makes it clear that this is, in the past, but now it's settled for less than full balance. So, and you're welcome to, get with me or get with Stephen, kind of offline about that, and we can chat about it. Or, if you want to put some more information, you can. Let's see. I sent a letter to LVMV Fundings stating they did not properly validate the debt. They never responded. Also still reporting. So this is a very interesting thing because we have these two different laws. We have the FDCPA and the FCRA. So the FDCPA is debt collectors like LVMV, and then the FCRA, and they kind of merge. And sometimes they fit together, sometimes they don't. So my first question would be, when did you send that validation letter? Was that within the 30-day time period? So LVNV, although they don't normally send out their own letters, but somebody on LVNV's behalf will send out a letter that says, hey, we'll assume this debt's valid unless you dispute it within 30 days. If you ask us in writing, we'll give you the original creditor, blah, blah, blah. If they did not respond to that and they're continuing to collect, then that's a problem. But if we just send it sort of a regular dispute letter asking them for stuff, they technically don't have to respond to that unless you do it within that 30-day window. And so they're allowed to still credit report on that. So maybe you can give us a little bit more information. And Stephen, what are your thoughts about that?
Never underestimate the value of finding an executive and sending a certified letter to an actual like compliance officer or somebody. And, you know, LinkedIn is actually a really good source to get names.
It is.
Honestly, I mean, you may not get their contact info, but at least, you know, get their name, and then you can, you know, call. Well, the big ones they're probably not going to know in their phone tree, but if it's a smaller one, hey, is so-and-so still work there? And then, of course, they do have third-party sites that you can subscribe to, usually fairly inexpensively, where you can actually find contact information. But I mean, I think that's really kind of like the most underutilized secret weapon, is to escalate things up to actual real humans. You know, and then from there, if they still disregard it, imagine how much stronger your CFPB complaint will be when you then send it to the CFPB. And, you know, because when they go to the CFPB, they route them to kind of like an escalation CFPB department at the furniture. So try that. See if you can find a real human and see how that works out for you.
Yeah, and I want to emphasize something Stephen said about certified mail. There is a relationship between how easy something is to send and how important it is. So you send a text or a quick email, that's fine, but it doesn't take much effort and it doesn't necessarily have a whole lot of value. But if you take the time to send a certified mail letter, and look, I'll put this company in that I use, and this is not any kind of like affiliate link or anything. Certified mail labels. Well, if I can spell, I think it's either it may not have an S on the end of it. I can't remember. Let me pull this up. It's Certified Mail Labels or Label or something like that. You'll find it's down in Orlando, Florida. But you can just upload your PDF and they'll send it out for you. And they add like $1 or $2 to it, but it's great. My point is, you send something certified mail, and you know this executive or compliance person that gets that, they go, okay, wow, I got a certified mail. You know, and I've mentioned this before. The joke in our office is, no good news comes by certified mail. Okay, certified mail is, I got something, I want to prove that you got it, and you're going to want to lie about getting it. You know, and so it just sends a message to them like, oh, this person, you know, he or she is crazy, and they're going to be relentless on this. So that can be worth the $8 to send. Let's see. BA says, had a case dismissed last month, went to trial right before plaintiff offered me a settlement agreement to dismiss the case if I agreed not to sue or share info. And they dismissed it without prejudice that day and wrote up contracts saying they would dismiss with prejudice within 14 days from when they received. Check today, they did submit the dismissal, but it was without prejudice again. Should I ask them to update the dismissal again? Is there anything else to do since they didn't follow our settlement agreement? Okay, so let's define a few terms here for everybody. Make sure we're on the same page. So if you're sued and a case is dismissed without prejudice, that's kind of like it was never filed. It doesn't really mean anything, okay? So if they had the right to sue you, then the day after it's dismissed without prejudice, they can sue you again, assuming they're still within that statute of limitation period. So with prejudice is what we call the sort of the fancy term, an adjudication upon the merits. It just means the case is over, it's done, it's finished. So it sounds like your deal was you signed the agreement and they'll do it with prejudice and they are not following their agreement. So what I would do if I was in your shoes, I would just, write to them. If you've got an email or you can send a letter or fax, just make sure you can prove that they received it and say, hey guys, I'm a little confused because here's the agreement with prejudice, but you submitted this without prejudice. I need you to fix this within 7 days, or tell me why you broke the agreement. And, a lot of times they'll do stuff like this because they figure people don't really know the difference. And, that debt still has value if it's dismissed without prejudice. It can be sold because you can be sued again. With prejudice, it has no value. And remember this, when you get it with prejudice, at least in my state and every state I've looked at, with prejudice means you won, which means that cannot be on your credit report. So I would be disputing that, if it's Midland or Capital One or whoever it is, dispute that on your credit reports to get that off of your reports. And I mean, right now we have, multiple lawsuits against all three bureaus and original creditors, debt collectors for this exact thing, where dismissed with prejudice, they kept it on our report, we sued them, and they didn't get it off. So definitely check that out. You have any thoughts to add to that, Stephen?
Sounds like you have a prejudice because you're saying you think they do that on purpose. That's
I do. It's funny that the collection guys never make a mistake against them. It's only against consumers. It's funny how it's like they flip a coin and heads I win, tails you lose.
It's a bona fide error, right?
That's right. Okay, so here's Clyde giving us some more information. Experian shows a $40, I guess, balance, Equifax 0, TransUnion 0, closed account. Yeah, I mean, I would be disputing it. If you think that you really owe nothing, I'd say, hey, Experian, I owe 0. By the way, Equifax shows this, TransUnion shows this. Why would there be a contradiction? And just point that out. Any words of wisdom, Mr. Stephen?
That's it. Pit them against each other. Well, I mean, I guess the other thing would be to look at the date reported. If one of them is reporting a different date than the others, they could theoretically still both be accurate. Let's say the $40 one was reporting in January and the $0 are reporting in March. So just take a look at that. But yeah, if they're reporting the same period, put them against each other, and put it in a letter and send it to all the bureaus and say, hey, which one is the accurate one? Because it can only have one balance.
Yeah, and I mentioned this to Stephen one time. This is from that movie Raising Arizona, where if you ever saw that comedy movie, so John Goodman, busts into the bank and he's got a shotgun and he says, "Everybody freeze! Everybody on the ground!" And this old guy in overalls is like, "Well, which one is it, young feller? Should I freeze? I can't get on the ground. Should I get on the ground? Then I'm in motion." And that's kind of the approach we use with the credit bureau. Like, which one is it? I mean, I can't owe 40 and 0. I can't be 60 days late and 30 days late. Which one is it? And so, it's a very reasonable position to take with the bureaus and whoever this furnisher is, Capital One or whoever. There's only one balance. There's only one date of last payment, So I would definitely do that. Let's see here. Sorry, I skipped Timothy here. My collection says my open day is when they got it, not the date I opened the credit card. Is that correct? So I'll let Stephen take that one first.
Yeah, so it's kind of odd, but if you look at the Metro 2 manual, which is called the Credit Reporting Resource Guide, it did really hard. You'll be able to find some versions of it online. It does state that for debt collections, the date open field is the date that they originally acquired the account.
Yeah, and I'll say this, that it is weird, okay? And I forget which bureau, one of the bureaus, at least on some of the versions of the report, they modify, instead of date open, it's like date placed for collection, which makes it more understandable. But this can be very helpful. I mean, I have a case right now where I have a collector that put the open date at a point in time, but then they are telling the court that they bought the account months and months and months after that open date. And I'm like, boys, you got a problem, because this open date means when you got the account. And so, they're trying to argue. It's like, no. It's very clear what the open date means. So, and this is why it's important, not necessarily if you're just doing this for yourself, but if you are running a credit repair place, you really need to understand Metro 2. Metro 2 is not the law, but Metro 2 is certainly persuasive to judges. And to be able to say, here's the industry guideline, this is what they say, that can be very, very helpful.
I'll add one thing to that, where you say it's not the law, and it's a really good point. And if for a point of perspective, because the word accuracy is not defined in the FCRA. I mean, it says that the report must be maximum possible accuracy, but there's no section of the FCRA where the word accuracy is actually defined. And so, any litigation is going to be arguing over what? Accuracy, right? So if you can't, like John said, if you can't use it as being persuasive, their own industry standard, then there's really nothing, in my opinion, that you can bring to a judge that would be persuasive, because you're having to define the word, because a word is not defined in the FCRA. So that's really where I think there's a big misunderstanding of the value and the power of using Metro 2, because it is, in fact, their industry standard that they've created and adopted to conform to that accuracy requirement.
Yeah, and the only sort of warning I will give is Metro 2 is controlled by the bureaus. And so we've got Equifax, Experian, TransUnion, and Innovis that really dictate this. And so when they get hammered in a court case, they'll go back and try and change Metro 2 to say, well, see, now we're compliant with industry standards. So that's why, as lawyers, we'll use Metro 2, and point out they can't even follow their own standards. But, I am always quick to remind the other side that, you can't just say, well, we can have 5 different last dates of payments, or we can, be totally off on, no, you can put whatever you want in Metro 2, but accuracy, we can just look in a dictionary and it means correct or consistent. And if we have these things that are different, then that's going to be a problem for them. So again, we're going into the weeds a little bit on Metro 2, but just understand it can be helpful. But, the other side knows that. And so they, try and change things to get around case decisions. And so sometimes we're fighting on that. Let's see. This is an interesting one.
That's Warren Maxwell.
Oh, Warren. Okay. And so, Stephen, give me your thoughts, or give Warren your thoughts, and then I'll share my thoughts. Can we sue a bureau for not removing an inaccurate address?
Well, if we look at what the FCRA says, then you can. If you look at 1681I, it says if the consumer disputes an item of information, and it doesn't narrow down what the word item of information is, and there's no regulations on 1681I. Like, you've got Regulation V, I believe, right? Regulation V overlays over the FCRA, but not that section. So it gives you the right to dispute an item of information. It's up to you to tell them what it is. Clearly, there's no debating that an address is an item of information. And so, I mean, then so you can, but then I guess it comes down to kind of the wins of what the judges are doing these days. And if you've got damages, I think that's really what it comes down to. Even though the FCRA doesn't require damages, a lot of your judges are going to kind of want to know how you've been damaged. So, I mean, I would say just kind of throw it in a lawsuit with a bunch of other things like actual trade lines. I mean, I would hope that you would have more than one inaccurate address that you're going to sue for. It's always easier to kind of throw the kitchen sink at them. But if you have literally just wanting to sue on that one trade line, you'll have to get the attorney's take on that, whether he feels confident or not.
Yeah, I'll say this. So let me take a step back. I think you should dispute inaccurate addresses, spellings of your name, dates of birth, phone numbers, places of employment, anything that's inaccurate. And part of that is to clean things up. I mean, you should be able to look at your report and it's got your address. Maybe if you moved in the last year or two, that previous one. But there's no reason that my landline that I had 15 years ago should still be on my credit report when I gave that landline up 15 years ago. That means nothing, okay? And it only allows the potential for somebody to pull my report, see that phone number, call somebody, or send a quote pre-approved offer to some bad address, and then I'm dealing with identity theft. So I would put all that in there. Now, if that's the only thing you have, I'm not sure I would sue just for that. I would be willing to look at it, but what you want to be able to do is paint this picture of, look, the Capital One account's wrong, and the Bank of America, and the Midland account. And by the way, there are 4 bad phone numbers and 3 bad addresses, and they've got my employer that I left 17 years ago, and they wouldn't fix any of that. And it just looks bad for them because they got to say to a judge, oh, well, that one was a mistake, and that one was a mistake, and that one. Well, I mean, how many mistakes can you have? At some point, the judge is like, come on, guys, this is your job. It's like the credit bureaus will say, we have 98% accuracy. Oh my goodness, can you imagine an air traffic controller saying that? Well, I only crashed 2 planes out of 100 in Atlanta. I mean, come on, that's pretty good. No, that's terrible.
You could work for Value Jet. So basically, by the way, all names have been are not really real names if Value Jet's listening. Like South Park.
It's just your opinion.
That's right, exactly. So what I heard you say was that if that address is the only thing, then Warren, you need to just try a little bit harder, find a few more things, and then go back to the attorney. That's basically what I heard, because we know you'll find some more things if you look hard enough.
We have confidence in you, Warren. Let's see. So is an E8 violation on account enough to go to litigation for, or should the account have caused more damage? So I'll just answer it this way. I sue on E8 cases, and we file those pretty frequently. Now, they're not, necessarily big cases, okay? I mean, we have some FCRA cases that when the defendants ask us, okay, what's your opening demand? It's mid 6 figures, okay? We don't do that on E8 case. An E8 case is much smaller than that. But here's the way I look at E8 cases is they have to delete the credit reporting, and they have to kill the debt. Or if it's an actual collection agency, usually we say, well, you guys got to pay off the debt, and then they got to pay some money. So you've heard of pay for delete. This is what we like to call the ultimate pay for delete. They pay you money to delete your account, okay? And so I would absolutely bring these unless the debt is really big. Now, if this is a $10,000 Midland account, do you want to sue them on an E8? Probably not, okay? But most collection accounts are, in the hundreds of dollars or maybe a couple grand. And now if it starts getting up, $4,000, $5,000, $6,000, then we have to look at it and say, do we think they might counterclaim against us? Are we worried about that? And but it's definitely worth talking to a lawyer about on an E8 case. So I would do that. Let's see. Ray says one account is showing 53 charge-offs with the original creditor. Original creditor is reporting monthly. Is this accurate? So this is a very frustrating thing, and I'm going to let Stephen break the frustrating news to you.
Yeah, so I think, Ray, what you're talking about is like the payment history profile where it shows charge-off, and that actually is how it's supposed to report, because what it is showing the historical status for that month. And so think of your credit report like kind of like this 3-dimensional picture, kind of like this hologram, and that historical data is supposed to report every single month back then. So it's really not accurate to say that it's showing 53 charge-offs. What it's showing is that for 53 months, at the reporting time during that month, it was in charge-off status. And so that is how it should report. Sometimes when you see these accounts and they're kind of like missing monthly payments and stuff, that's actually a problem because they're supposed to report it every month. So just think of it kind of like when you look at the report, the top part has like kind of like the current data, like your current balance, your current limit. Some of these reports, when they give them to you, they actually do give you a little more historical data. But actually, if you think about it, all of those fields that they give you, where it's just like your current balance, your current limit, they have historical balances and historical limits and historical high credits that would go back in time 53 months, just as much as that payment history. The issue is that the reports that we get are incomplete, i.e. also inaccurate, because they really just a lot of times don't give that to you. So you've got kind of your historical status, and then you've got kind of the current status. So what's that what that's reflecting is just that for 53 months, it was in charge-off status.
Yeah, and it's frustrating because you look at that and you see that CO all the way across. I would look at that, Ray, and see, is there any missing data? Usually if they're reporting that long a period, there's going to be 1 or 2 months where there's no data. That gives you an opportunity to dispute and say, hey, you're not reporting anything for June 2016. Fix it or delete the whole account. And the bureaus like to argue, well, maybe we didn't get the data. Well, then go get it. If you're going to report over a period of time, you better have all the data. And we have some experts in the training group, and Doug Hollins one, and he talks about the data is provided to the bureaus. The bureaus own that data. They want to kind of push it off. Like, oh, that's the furnisher. No, you say you own that data. So if it's incomplete, go get the rest of it. And so I would just look for anything that looks inaccurate that you can dispute, and that may help you out there. Let's see, our good friend Cedric Carr here. Debt collector calls by phone. Is that an initial communication? Yes. So if they don't send the required information per 1692GA, that's under the FTCPA, is that a violation? Yes. They have 5 days to send it. How many days should I give them to send it? So here's the only thing is, and this may sound a little bit like kind of semantics, but they have to mail you the letter within 5 days. They do not have to make sure you get it. Now, if they don't put the proper address, they don't put a stamp on it, that's going to be a problem. But they're not required to make sure you get it. So, and I'll tell you this, I mean, I've mailed stuff this last year where, people are getting it months later. We have an awesome postal service, but it has problems. And so, that's most lawyers I know won't sue on the failure to receive a 1692G notice, because it's very easy for the debt collector to just lie and go, yeah, we mailed that. Well, I mean, how do you prove they did not mail it? They'll get somebody to raise their hand, whether they're telling the truth or not, to say, oh yeah, we put an envelope, we put a stamp on it, properly addressed, it didn't come back. Well, then, that's a challenge. Okay. And so you could always ask them for it again. Now it gives them a chance to sort of, make it up. But here's the other way to look at it. If they're not sending that, they're going to violate the law in other ways too. So you just got to give them an opportunity to do that.
Look, Warren just posted 2 yeses for Cedric. He liked that. You were like, yes and yes.
Let's see here. Jeff, I sent a pay for delete offer letter certified to Amsure. So for those not in Alabama, Amsure is a huge collection agency in Birmingham, mainly medical debt, but more than that. They have not responded. I'm wondering why. Why wouldn't they agree to pay for delete? So some companies just don't like to do it. And what I would do is, if you said that you disputed the debt in that letter, and you can do both. You can say, I dispute this debt and I'm interested in doing a pay for delete. Then check your credit report, see have they updated your report without marking it as disputed. And that's that 1692E8 violation we've been talking about. But the other way is just to call them. Sometimes when you get them on the phone, they say, well, Jeff, you owe $300. And you say, well, look, I can pay you $100. They go, pay us $200. You say, okay, I'll do it if you'll delete it. Then see, they're already spending that money. It doesn't sound like much, but Walmart makes a ton of money with little bitty profit margin.
Collection guys work on commission, right? How much? It's like they're basically sales guys, is what they are.
Yeah. And so it's sort of like
for $200.
If you visualize like sliding the money across the table, but keeping your hand on it and say, now I'm going to need to pull this back if I don't get that deletion. Now you're taking money out of their pocket. You're taking food out of their little babies' mouths, right? And so sometimes it can be effective to do it over the phone. A letter, then it sort of gets to compliance and all these people, and they may, not agree to it. But just get that collector on the phone, and you'll probably be able to get that. And if they lie to you, they say they'll delete it, you pay them, they don't delete it. I love suing Hampshire, so they're about 3 miles from my office, so get with me on that. Let's see here.
The movie Boiler Room. You remember the Boiler Room?
Yeah.
And then, when they're trying to sell the stuff, and whenever they get a buyer on the line, they put on mute and they kind of yell across the sales room, "Recco!" That's basically what happens at those debt collectors. When you give them a buying sign, they get all excited, and they're like, "Dude, I'm making a commission on your ass," They
do. So here we got some more details from Lawyer by Day. The account is designated as paid and closed, but simultaneously over 120 days past due, and a comment saying paid for less than full. Well, I would look at that and say that's accurate. That the way judges are looking at these status cases is they're saying, can somebody look at this and be deceived? Whether that's the law or not doesn't really matter. When the guy or gal in black robe says it's the law, that's the law. So, this would not confuse anybody into thinking that you still owe the debt, because it does say paid and closed, and it says paid for less than full balance. So it's frustrating, but I would not sue on that, as I understand it. You have some thoughts on that, Stephen?
Couldn't have said it better myself. Yeah, no, I mean, it looks accurate to me as well.
So Miss Michelle here sent a validation letter. They responded with a billing statement, previous owners, date of ownership, never dating when they received it. They gave me 30 days to respond. I did disagree. And then I think we have a follow-up here. They closed the account on TransUnion, but it's still on my credit report. So going back to this, so the debt validation, and this is under 1692G, most courts say there's very little that has to be provided to you in response, unless you're very specific with what you need and explain why you need it. And so, I mean, some courts say literally the debt collector can say, hey, we called the original creditor and they told us you owe it, so we're good to go. Or if they own the debt, they can go, we checked with ourselves and you owe it. Okay. And so there's not a whole lot. We got to give them really good reasons, like, here's why I need this information. So the fact that they didn't send you a whole lot and then they gave you 30 days to respond, you did. I mean, you're doing it the right way. And, the deal would be, is it marked as disputed? That really is kind of the low-hanging fruit. If it's marked as disputed, it generally is not going to impact your credit score for most of the scoring models. Now, it might affect you for underwriting. If you're trying to get a loan, somebody may see that and say, well, we got to deal with this collection account. But I would look and see, is it marked as disputed? And is there anything that's odd about the account? Like, let me give you an example. You may have portfolio recovery, and it says you owe $5,000, and you send them a validation letter, and they send you statements showing that it's $4,692. Well, guess what? $4,692 ain't $5,000.
Oh, but it's close. It's close.
I think we should round down on debt collectors, really. No rounding up. But that might give you a basis to dispute it and say, hey, I think the balance is wrong. Look, here's the documents they sent me. These don't match the credit report. So TransUnion, I'm asking you to get this off. And definitely check Equifax and Experian, even Innovis, to see, are there different amounts on there, different open dates? I mean, that's sort of amusing when you see a debt collector. Remember, a debt collector open dates when they receive the account. Well, Equifax will say January, and TransUnion will say February, and Experian will say March. There's only one open date. And so you're using that data by all those bureaus against them to create or to discover the errors. And so that's what I would say on that one. So Damian Campbell, Experian working fax number. I never fax to the bureau, so I don't know. Do we have that, Stephen?
Yeah, email me, Stephen at stephenpalmieri.com. I don't have it offhand, but there is a number that I can get over to you. Yeah.
Okay. Let's see, Clyde. Oh, wait, I may have.
Dude, we're going backwards. We're going backwards, John.
Let's see. Okay, this is just a follow-up. So the account's charged off. I don't have the card anymore, and they keep saying it's verified. That's not true. Well, I would just make sure, like we said, Clyde, dispute it by pointing out any differences between these bureaus. So you got to be really, really, really specific in your dispute letters. And we can't just say, I think there are errors. I'm not saying you did this, but a lot of people just say, well, I think there are errors, or please verify this. That doesn't do you any good from a legal standpoint. So you want to pinpoint the exact errors on here, all the discrepancies, all the times where the information is sort of going like this. It's supposed to fit together perfectly among the bureaus, but there'll be sort of butting heads. And so that's what I would do there. So let's see. We have a 7th Hanuman. Okay. Hello, gentlemen. I'm an identity theft victim. Police report, FTC affidavit, IRS letter, fraud, or request block a fraud account, Equifax, and Experian. They both denied.
This is like the boiler room moment where John's like, Recco! Nothing more than a sue for identity theft. So 7th Hanuman, you're kind of like the reason he had the show today. So come on down.
Get with me on this. I'll give you the very easy
that
way.
Six-figure settlement offer that he says he starts off with,
Just in all seriousness, you can get with me through my law firm, which is alabamaconsumer.com. And but here's the deal on what you've got. And let me go back. This is great. We've got all these comments. I'm kind of losing my place. But if there's an account that truly is identity theft and you've gone through all these steps, then the bureaus are in a very, very dangerous position to refuse to fix that. I mean, I'll tell you this, it's very unusual in my experience. When we help people dispute stuff with identity theft, they always fix it, okay? And because they're very scared of it. Because you can have the most sort of, let's do stereotypes, the most, business-oriented, Republican, never been late in my life on anything. They're sitting on a jury with identity theft. They're like, ooh, that could be me. I could be a victim of identity theft. And so the bureaus are scared of these cases. And so I would just say, get all your information together, make sure that you've, dotted every I, crossed every T.
One other thing I'll add is the FCRA does have a provision that allows you, the victim, in this case, not the consumer, they call it the victim, but to write to the business entity and get, in this case, the original records. This is like really the only spot where you can get original records, and it gives them like immunity from, like, if they're releasing these records, but clearly you weren't the one who originally went to their store because it was like somebody pretending to be you. They've got kind of immunity. They can release the records to you, and like they can't be sued for releasing them, and you can't enforce them if they don't give them to you, but you do have a provision in the FCRA if you're the victim of fraud to be able to write to the business entity that opened the account and say, please give me all records related to this. And so if you've gotten kind of like, basically, if they've told you no, what I would do is I would write to the original creditor, the business, and ask them to get you all records. Again, you can't enforce it if they don't give them to you, but there is that provision in there where they're supposed to give you your records. And then from there, if you get them and you see that they're clearly not your signature, resend it all out to the bureaus. And then if they still deny it, I think you'll be in a much stronger position to go to somebody like John.
Yeah, so just kind of see exactly where you are, and you may have already done all those things, and just reach out to us. Let's see. Miro says, what do you think about Biden canceling the credit bureaus? And we're not going to make this a political show, okay? Because it doesn't matter whether I'm, conservative or liberal, or Steve's conservative or liberal. I think most everybody would agree Biden has been very free with executive orders. Okay. And, he has had some talk about canceling the credit bureau. I don't think there's a chance in the world that will happen. And he's got,
well, I mean, think of it like this. I always joke, I'm like, it's like getting on the no-fly list, right? If you get accidentally on the no-fly list, good luck, right? I mean, last thing you want is the government in charge. I mean, let's just be honest, the government is not the one that, like, the credit bureaus are not the ones that cause people to pay things late, right? I mean, it is what it is. And so I'd much rather go to war with public credit bureaus than with the government.
Yeah.
So,
and a lot of times the government has immunity. And so,
right.
do you really want that? And I know Mirio's not asking, is this good or bad necessarily, but I think it would be bad for consumers. I mean, right now we do have some competition, but between these bureaus, and the more we can sue them, and they discover that it costs more money to break the law than to follow the law, they'll get better. And that's the free market. And like I said, I think Biden he's got this infrastructure thing. He just did a bunch of executive orders on guns. I mean, I think credit bureaus are way down his list. I think down on Stevens borders, there's a little development down there, and in Texas and Arizona. So I think he's got his plate full, and trying to put Equifax, Experian, and TransUnion, these multinational companies, out of business. I think he'll have to wait on that.
Yeah, he's got some really good temporary housing facilities in South Texas right now.
So let's see. Clyde says, I have my name wrong. My dad and I have same name, but I'm the second. They won't change it. And my D shows I'm second.
Well, that's another juicy one, Clyde. Just say no more. Just go ahead and just sign his retainer agreement, and just give him your file. Mixed files. We love that.
The thing about that is the bureaus are sort of casual about this. Well, you're a third, you're a second, you're a junior, you're a senior. Well, it doesn't matter.
It's just we're missing one digit, one letter.
We don't necessarily want our fathers to know what's on our credit report, or maybe we don't want our sons to know, or whatever. And the point is, go back to what Steven said a while back. You can dispute any inaccurate item on the credit report. Well, what's an item on the credit report? Anything on the credit report. If they list my name and they misspell it, I can dispute that, and they have to investigate it. Now, if they have my name, which is John, if they have it Jon, would I sue for that? I don't know. Maybe not. But to me, this is a lot worse, because, if they have Jong Watts, well, they're trying to say that's me, but here they're mixing you up with your dad. And I would be very, very careful in looking at all the accounts and make sure none of the accounts are going back and forth. And the last thing is just to make sure that if you're telling them they have to fix it, make sure that you always use the second. In other words, you don't want them to be able to say in litigation, well, here are 5 accounts you opened up, and you did it as Clyde Horn, not Clyde Horn the second. So you got to make sure you're consistent about it if we're going to hold their feet to the fire.
And what I would say is take your dispute and actually turn it into an affidavit and get it notarized. I mean, because this is a pretty simple thing. This is like a mixed file, essentially. You're mixed with your dad. Put in an affidavit and say, I am, and even if give them the story. If you know the story, hey, the story is this is my dad and this is me. And so now I'm telling you in a sworn statement. And that should get escalated up. And if it doesn't, you're going to be in a much stronger position to go to a guy like John. You shouldn't have to put it in an affidavit, but obviously if you do, since they're already giving you the runaround, that's the strongest type of dispute that you can do.
Yeah, and you can get it as an affidavit just by going to a notary public, at like a UPS store, a bank, and they'll notarize it. It doesn't make it magical. It just means this is really you doing it. And, there's some language you can put in that, this is based on personal knowledge and this is the truth. And it does just make it have the appearance of more reliability. Let's see. Neva, miss, someone opened a school loan in my name, found out from a creditor asking for money, get a police report. And so it sounds like you did that. They didn't help you. So you went to the online school. They wouldn't help without a court order or subpoena. And so, that's identity theft. So exactly what we've been talking about. Get a police report, get identity theft affidavit. You go to the bureaus because what you're doing makes total sense. This is the common sense approach. You would go to the creditor and say, hey guys, you made a mistake. Or you go to the school, hey guys, you made a mistake. But you have to go to the bureaus. Now, it can get a little tricky if this is a federal loan versus a private loan. This is probably a private loan, I'm guessing, but you can tell us if it's a federal. Federal is a little more complicated, but you just go to the bureaus and say, this is not me, get off my credit report. Now, that doesn't make the debt go away. It gets it off your report. And then if they try and sue you, of course, you have a perfect defense. It's not me. If we just take a step back and think about if Capital One sues me and they say, John, you owe us $10,000 because you took out this account and you didn't pay it. And if my defense is, I never took out the account. I mean, if I'm successful in that, they lose. So, we never owe money for identity theft unless we're involved in the scheme or like the joke is your wife steals your identity, opens up a credit card. She says, hey, I got a $20,000 credit card. You're like, great, let's go on a round the world trip. Well, you're stuck with that. Okay. You can't benefit from it. Okay. At least knowingly benefit from it. So I would definitely look at disputing that through the bureaus and just load them up with information, affidavit, identity theft affidavit, police report, all that sort of stuff. And let's see, here's some more information. Joint account on an auto loan showing different 30 days late for each joint owner. Okay, that's very interesting. So person A is late January, April, and September, no late in 2016. And B is February, June, July. Okay. So I'll let you have fun with that one, Stephen.
Well, yeah, I mean, that's, it's interesting, okay, because there are two different consumer credit files. So now what you need to do is kind of, if you're working on both of those consumers, you would want to put a dispute together and you could use the other consumer's credit file to kind of audit this one against and say, hey, I mean, this is illogical because it's a joint account. Here's the other consumer's credit report, and they're reporting inconsistently. So you guys need to figure it out. So I would put the copies of both consumers' trade lines, the report image, I would put that in with your dispute and send it out that way.
Yeah, that's very good. And do keep in mind, I mean, so for person A, if they really were late those days, well, you shouldn't be challenging that. But for person B, you should be challenging theirs because it's different, So, but you definitely are, on the concept here, which is we want to take the reports that are out there, whether it's my 3 reports or my spouse's reports and my reports or whoever it is, and say, look, there's no way all this can be. This is just inconsistent. It'd be like saying, ESPN says the Tampa Bay Buccaneers won the Super Bowl. And Sports Illustrated says, no, Kansas won the Super Bowl. Well, you can't have both of them. Like one of those is wrong. Maybe they're both wrong, but at least one of those is wrong. And so whether it's your own reports, and when we say your own reports, it could be this Equifax report and then this other Equifax, they're showing all these different data, and you can point that out. And Stephen, I know you've seen this where like the paper copy says one thing dated, April the 10th, 2021, and the online version says something different, same date. Well, you could use those. I mean, I've written dispute letters for clients where we say, I'm really confused because my Equifax.com says this, the paper copy says this, annual credit report says, which one is it, guys? It can't be all these different things. Let's see. So Golden Gate, being sued by a collection attorney for a debt, tried to serve me at the wrong address, 13,000. Will he give up? So some of that depends on the court. We have technically the rules of most states say you have about 120 days to serve somebody. I've had cases where the judge will allow somebody to be served after 5 years. Okay, so think about that. They were sued like in 2015, they get served in 2020. Other judges will say, hey, 120 days, I'm dismissing your case with prejudice because you didn't get the person served. So it's really pretty dependent on your court, your state. And when I say your court, I mean like literally your judge. Because you could have judges down the hall from each other that take radically different approaches here.
Depends on whether you contributed to that judge's reelection campaign or not.
Now, Stephen, that doesn't have anything to do with this. So I'm offended you would say that.
That's right. That's just a little humor right there. That's the sound.
Let's see. I have a couple accounts that report separately. Midland shows TransUnion Experian. Further down my report, Experian is separate. Does that count as duplicate? So, Gerald, I think you may be talking about on like a 3-in-1 report, like a Smart Credit, Identity IQ, where sometimes you'll see, 2 bureaus here, and then you flip like 2 or 3 pages, and then there's a Midland account can be on all 3 reports. It might be that they have slightly different account numbers because some bureaus will sort of block out the first 3 or 4 digits, and other bureaus may block out the last 3 or 4 digits. And so sometimes on those credit monitoring, they get separated, which is why if you were with us earlier, particularly the lawyers that do this type of stuff, we harp on you got to have your real reports from annualcreditreport.com or directly from the bureaus. And so I would check out your real reports and see what they show there. What do you think about that, Stephen?
Yeah, I mean, basically these monitoring reports, they try to essentially kind of consolidate or merge, in one row. But it's if it's mismatched up in the monitoring, if the trade line still is only showing on like the Experian column one time and the TransUnion column another time, it doesn't really matter if the monitoring matched them up. It wouldn't be a duplicate listing.
Yeah. And look, it's very handy when they can get all 3 across the row because it makes it easier to analyze that data and go, hey, here's a difference. So it's very nice when that works, but it just doesn't always work. Let's see. Trump put someone in charge of the post office, slow the mail. He succeeded. Okay. Maybe so. Let's see. Auto loan above. Those are lates after disputed for each individually. Okay. Yeah, that's, I guess the question would be, I think that's one where we had person A and person B and they had different. Did person A reference the other person's credit reports and the way it was reporting, or were they sent totally separate? You might want to, if they weren't done sort of in connection with each other, you might send another dispute and say, hey, this is what you're reporting on me, but on my wife or on my son or whoever, you're reporting something different. And then their letter would say the same thing, but talk about me. So you might try that. Let's see here. Somebody wrote leverage. Well, that's what we're trying to get is leverage to get these guys to do the right thing. Let's see. Here is Marnay. I hope I'm saying your name right. Marnay Kennedy. Can I sue bank if Truth in Lending Act states about finance charges were charged when we know finance charges, sum of all charges, no rescission was offered either? I will tell you this. I have sued under Truth in Lending Act. That is not an area that I do much in. It's kind of funny in the consumer world. You have some guys that are they'll only do FDCPA or only FCRA, but most of us do both. But like TILA, Truth in Lending Act, those are like a separate breed of people, because they'll like dig through a document and figure out there's like a rounding error and this is a class action. And I don't say that in a bad way. I'm just saying, at least for me, I am not up on that part of TILA.
And I would say that there's no rescission requirement for auto loans. So that's only for like certain types of loans, especially kind of like second mortgages backed by your home and a few other exceptions. So if your issue is that a car was delivered without a right to rescind, that wouldn't really be a Truth in Lending Act requirement.
Yeah, and that's going to be more state law. You might have a state law that requires it. But like Stephen said, normally so the few cases I've handled with rescission issues, those have been mortgages. And the basic idea is, you get a second mortgage, you've got this 3-day right of rescission. And so I would just check that out and see, maybe we're wrong on that. Maybe it does apply to car loans. That's not my memory though. Let's see. Why do some creditors not send derogatory accounts after a long period of time to collection agency? Status is under collection charge-off. No collection agency has it, assuming they sent to their internal collection department. Well, each company can make their own decisions. They may want to keep it in-house. They may feel like they're worried about reputational risk. In other words, if I'm a credit card company, Stephen owes me money, and I send it to Jack, break your kneecap Smith, and he goes after Stephen. Well, that may reflect badly on me, and so I may want to keep it in house and sort of control it. And then you have like Chase, for example. They got busted maybe a decade ago with these fake affidavits in their collection lawsuits. I mean, they had like people notarizing stuff, and the notary had been dead like 6 months before the affidavit was notarized. That's hard to explain unless, they had like a seance and brought them back. And, like we brought you back from the dead just to sign a stack of affidavits, And so, Chase doesn't normally sue. Now they'll sell the debt, but it really just each company can decide what to do.
Yeah, you can have internal collections, like you said. That's Elvis Garcia's question, I believe. So yeah, it can be internally collected without being transferred to a third party.
So here's an interesting one from April. Can a charge-off report interest each month? And so what I think you're saying is like it's $1,000 this month, and next month it's $1,050 because there's interest, and then $1,100 and so on. What do you say about that, Mr. Metro 2?
Well, I mean, I wouldn't even say that's a Metro 2 thing if it's in the contract, because the charge-off is really just kind of an accounting condition. They're writing it off as a loss in their books, but if it says, upon default, we're going to charge you XYZ interest rate, then to charge it off, you're going to be in default. So yeah, if there's interest rate provisions in the agreement for charge off as part of default, then I don't think that there's an issue with that.
Yeah, and you'd also want to know what type of account it is. Has it been closed? There are certain rules that apply depending on, is this a credit card or what this is. When it's closed and charged off, they may not be allowed to add more interest to it. So you want to know exactly what type of debt it is. And generally that's going to be a federal issue, but it can be a state law issue. And one thing you can always do is write to the company and say, hey, I noticed you're adding interest to this. What's your authority for it? Questions are very, very powerful things. You don't have to, make a threat. You can just say, I'm curious. Show me your authority to charge me interest. Because sometimes you get a letter back saying, oh, there was a computer glitch and we've deleted this account. So it's worth a certified mail letter. Let's see. Okay, this is back on our identity theft. Creditor asked me to provide a police report. They asked me to provide 3 signatures, and I did. And then I think we have a follow-up down here. Good thing is we have a lot of comments here. They wouldn't help, so I went to online school. I had to get a court order. So, again, I think you're kind of in this frustrating situation where it feels like you're running into a brick wall trying to deal directly with the school and the creditor. I would go to the credit bureaus that this is reporting and try to get this thing knocked off. And then if they ever come after you in a collection suit, you've got a phenomenal defense if it's not yours. So I would definitely do that. So let's see here. We have, oh, the truth is coming out. Steve is
Yeah, that was big Warren G. Maxwell.
Warren dropping some truth here on us here. All right. So Muriel, smash the like button. Well, thank you very much. And then somebody says not going to happen. Not sure who that was, but if it's something Steven said, then I'm in agreement that should not happen. So, and if I said it, it's 50-50 whether I'm in agreement or not. All right, so let's see here. We have somebody. I have 6 closed credit builder accounts showing closed. Will showing closed be a problem buying a house? Should I get them removed? So, Stephen, maybe you can define for us, what is a credit builder account? Maybe some examples.
Well, yeah, it could be either like a little secured credit card. Sometimes there's these merchant accounts that like will give you a $2,000 or a $5,000 limit if you pay like a little upfront fee. So just different accounts that are basically they're kind of geared towards people with subprime credit to help them build it up.
Okay, and then if he has or he or she has 6 of these and they're showing closed, is that going to hurt them typically when they're buying a house?
Well, I'd say that's really more of an underwriting question. Like, what is your underwriting guidelines? Like, do they want to, how many closed accounts? I mean, from the score perspective, though, yeah, if you close them, it's going to start to lower your score as time goes on because they're no longer open and you don't have that available credit. So part of the value of the credit builder cards is it gives you more available credit. If you get a $5,000 merchant card that reports, all of a sudden you've now got a revolving with 5,000 available. If it's closed, you no longer have that available credit, which can affect your score, and it's also a closed account. So, I mean, I guess my question would be, if you're trying to get a mortgage, why are they closed? But I would think that probably just talk to your mortgage person, and if your score is still good enough with them closed, then you'll be fine.
Yeah, and that brings a very, very good point that Stephen made. We have scoring and we have underwriting, and these are 2 different things. So I might have a great credit score, but underwriting looks at me and they say, we're not loaning you $1, okay? Or I might could fly through underwriting, but maybe my income is good and my debt's low, but my credit score is terrible and I never get to underwriting. So you typically go to somebody about the score. You go to a credit repair company, talk to them about the score, but you need to talk to your mortgage broker about underwriting and say, okay, look at my reports. Now you tell me, because here's the thing, just because your next door neighbor used the same broker, it doesn't mean it's the same underwriting. She may have been in a different program. And I mean, these programs vary wildly. It's sort of like somebody saying, well, my credit score is 675. Is that good? I have no idea. Is this your Vantage score? Is this your FICO? Well, if it's your FICO score, which FICO score? There's like a dozen or 2 dozen FICO scores. So, you really need to know the details. And that's why I would get with a good mortgage broker, as soon as you can, to say, here's what I've got. You tell me what I need to do. Because ultimately that mortgage broker is making the decision. It's not a lawyer like me. It's not a credit repair person. I mean, the mortgage broker is the one speaking on behalf of the person that has the big checkbook that can write you the check to buy the house. Let's see. Can't get a car loan or home mortgage because of it's very frustrating. That's going to be because of your credit score and what's on your credit report. So again, that's why you need to go to the credit bureaus. Let's see, lawyer by day. What does the status updated field represent? In this file, all 3 bureaus have a different date. We got March 2021 and 1 charge off. Isn't this re-aging? So this will be something, you see my Metro 2 guy's face lights up. He's like, oh, let me tell you, this is field, blah, 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 blah. So
it's not even a field. That's like Experian has that. That's them being lazy asses is what it is, because they want to make the reports look as pretty as possible with giving you as little data as possible. There should be the current status for every month historically, just like we talked earlier, like there's a historical payment history and all these other and like the charge off for 53 months, like there should be a status reported every month as well, but it's probably an Experian report. They're just like, okay, we've got the status listed as this, and it turned into this status on this date. So basically, that's the date that whatever the current status is came into effect. But so the status updated is actually not even really a Metro 2 field. But they're just saying if like current status is charged off, it became charged off on whatever date that they're giving you. And then you say they've got two of March of 2021, and one has the charge off date. Let's see, isn't this re-aging? So the re-aging, as far as for like the 7-year purge clock to be able to where they have to delete it, that's calculated from the date of first delinquency, not the date of last activity, the date of first delinquency. And Equifax is actually the only bureau that gives you that date. Experian and TransUnion don't. So, so if you're talking about re-aging, like the 7-year purge time frame, nothing on that report, unless it's an Equifax report, would have the information that would indicate where that 7-year clock actually started from.
Yeah, and what can make this confusing? So we have the date of first delinquency. That, as Stephen said, is your trigger. Sometimes Equifax uses the date of last activity as the date of first delinquency, but not always. And so it can be confusing. And again, that's the power of questions. You write to the bureau and you say, why are you doing this? Why are you doing that? Explain it to me. They never will. Okay, so I don't want to set you up for disappointment. They will never respond to you. But the point is, if you ask these questions to the bureau and then say, this looks like it's inaccurate to me, I want you to fix it unless you can explain this to me, and you just get this, sort of robot responding to you, that's very frustrating. And, it allows us to argue in court. It's like, well, I mean, why wouldn't you just pick up the phone and call this person? Why wouldn't you write them a letter and explain it? And you can imagine the bureaus are a little reluctant to say, because we don't care anything about anybody that's disputing. Those are not our customers. We have no desire to help. They're not supposed to say that. So, oh, well, we get so many disputes and it's all automated and we couldn't possibly respond. Well, why not? I didn't ask you to keep a credit file on me, but I'm asking you questions on the credit file that you're keeping on me. And you just get, automated responses back. So let's see here. We'll do, Stephen, we're coming up on 90 minutes here, so we can wrap this up in a moment. So we've got, are you less likely to be sued a creditor so you have hired a lawyer in the past for defense? So you would think so. And I'm sure there are some times when it does help, but I know we've had, folks that we've represented, we've won their case, and then they get sued again by the same company. And you'd think they would be a little smarter than that. And so it's not always protection, but it's good to have a lawyer that you've used in the past. You would think so. So now we're, I'm talking from the past now, apparently.
Yeah, I'm fine. I'm clicking so much. Sorry about that.
So, if you've got a lawyer that you've hired to help you defend cases, I would just, keep that lawyer sort of on speed dial if you get served again or you think you're being sued, and get them to help you again. Let's see. How can accounts being reported on just one bureau be disputed if you can? Maybe that's if you cannot find discrepancies. Do we just rely on the client's documents to dispute? Okay, yeah. So, Stephen, why don't you take that one?
Yeah, I mean, of course, you won't be able to compare one bureau against the other for inconsistencies, but still, the bureaus are still not going to give you all of the data fields. They all kind of have their particular fields that they don't give you. So if you look at the Metro 2 manual and you just kind of learn how to map them out, hey, this is incomplete reporting, which is inaccurate. I don't have this information. And then a lot of times there is stuff that is still just missing. Like you may have like no payment, like no monthly payment on accounts, like monthly payment of not reported. So you would just need to audit it not against not on like an inconsistency basis against other bureaus, but you could still audit it based on Metro 2. And if it's either the field is not disclosed or if it's just not there at all, that's a way where you could definitely do a good, well-rounded dispute.
Yeah, and let me give you an example of that. Let's say that you do have an Equifax report, and it says date of first delinquency is June 2018. And then you look in the payment history, in June 2018, it says okay, or good, or current. Well, that's inconsistent, because on one hand, they're saying June 2018 was the date of your first delinquency, but it says you were current on the payment history. So something is wrong there. And so just kind of look at this. And, in my office, we use a spreadsheet. We sort of get all the data into the spreadsheet to be able to look at it. And sometimes even previous reports, because you'll see that, maybe there's a 30-day late and it keeps moving around. Well, what's going on, Equifax? Why does this keep moving around here? And which one is correct? And so, and then you can also, we talk about discrepancies. That's not the only way to dispute. I mean, sometimes the dispute is simply, this is not right. It shows a balance, and here's my letter where I settled the debt, or here's my court order where I won my case, and they're still showing a balance. And so, this is discrepancies. That's one way to do it, but you also can certainly use your client's documents. That's, it's not an either or, it's let's use both here. Let's see. Okay, we have Cedric. Apparently he's going on a road trip here. So, definitely swing by. And
he's going to hit us both up. Alabama.
Yeah, we'll feed you in both places. How about that?
He'll see which one's barbecue is better,
I'm pretty sure I know about that. All right. So John says, my question is about responding with a letter to the collection company for valuation, and in Washington State valuation, they're licensed to operate in state. So I'm not sure on evaluate if you mean validation. It certainly can do that. And if your state says a debt collector has to be licensed, and if they're not, they can't collect, then I would definitely ask about that. Usually for attorneys, if they are licensed by, in your example, Washington State Bar, they typically would not have to be licensed as a collector. But again, your state may be different on that. So again, there's nothing wrong with asking questions of these debt collectors and see what you get back. Sometimes merely asking the question makes them get concerned, and they may go away. So what is it in Texas, Stephen? Do collection agencies be licensed there?
Yeah, debt collectors are required to be licensed. They're not required to respond to consumers' requests to verify, but they do have to have a license in Texas.
Yeah, and that's a good point. You may have with it may be the banking department, commerce department, somebody in Washington will keep this list, and that should be publicly available. So you can always look them up and see. And okay, not responded. So yeah, I would, contact your Secretary of State, banking department, somebody there. You probably can just Google it and find out, hey, is, portfolio recovery licensed in Washington? And it's amazing. I mean, Midland has been caught doing this. I want to say 4 or 5 years ago in Maryland, they got hammered because they didn't have the proper license. How can Midland, Midland files usually 1,000 lawsuits a month in Alabama, just Alabama. How can a company that big totally botch it on the licensing? But it happens
because they're that big.
yeah.
Nobody was paying attention.
That's right. Let's see. So Stephanie says, hey, Stephanie, good to see you.
Like another YouTube celebrity. She's too.
Yeah, she has good videos. Angel says, can you guys see my question? So yes, we can. And if I missed it, I apologize. It kind of bounces around using this StreamYard thing. So if you don't mind asking that again, if we missed your question. Are debt collectors more likely to open your certified letter if you write payment enclosed? I would say this, they're they're just going to open your certified letter regardless. I wouldn't put payment enclosed unless you really put payment in there. If they get your letter and you can prove they got your letter, which is the whole point of certified mail, and they don't open it, they're charged with the knowledge. In other words, if my letter says, hey, I refuse to pay you and I dispute this debt, and then they write me and call me, well, guess what? They violated the law, because the refuse to pay is a ceased communication. And their defense is, well, we didn't read your letter. Too bad, buddy. Well, we didn't read your letter, so we didn't mark your account as disputed. Too bad, you're getting sued. So we don't really care if they read it. We just want it delivered. And then it's up to them if they want. It's sort of like this. I help people with not like small back taxes, okay, but somebody says, I got $80,000, $200,000 and back taxes to the IRS. They're like levying and doing all this crazy stuff. Well, trust me, it's not a defense to say, hey, IRS, here's a grocery sack of all the IRS letters. My client never opened them. It doesn't matter. They're like, we sent it, you got it, you're on the hook for it. So let's see. Joshua says, thanks for presentation. Any concerns about credit report not showing accruing interest? So if I understand what you're saying, let's say it's $1,000 and maybe there is $50 a month in interest, and that's not showing on the credit report. It might be technically inaccurate, but I think that would be one of those things. If we sued on that, the judge would say, so you want them to make it worse for you? And there's been a lot of litigation over interest, and particularly in the Second Circuit, which is basically like New York. And
Metro, because Metro 2, that would be your balance field, and your balance field, it kind of defines in there exactly what's supposed to be in there, and interest should be in there. So if John has one of those good old white judges that's like, you want me to make it worse, just pull out the Metro 2 field and say, no, we just want it to be accurate.
Yeah, it's sort of the thing when you catch somebody breaking the law in one area, they're probably breaking it in other areas. And so that's an invitation to look deeply. And Josh, I know that you are good at finding stuff. So I would definitely look deeply on that. Let's see, I purchased home 2013 in Birmingham. 2019, someone was able to get a quick claim deed on the property because they paid the back taxes. And what can I do about it? So this is very state specific, talking about property taxes and tax sale deeds. And even in Alabama, it sort of varies by county a little bit. Lee, if you'll get with me, and I will connect you with who I think is the best authority on this in Alabama. And you can chat with her, and I think she could guide you through that. I help people with foreclosures, fighting against foreclosures, reversing foreclosures, but I don't do a whole lot with the tax sales here. Let's see. This is on the credit builder. There were 6 $1,000 loans paid back over 6 months to build my score. It worked, so I no longer continued. So I purchased out. Yeah, if it's worked on your score, that's great. And like Stephen mentioned, just check with underwriting and make sure that's not going to be. I don't think it will if they were current. And now those would be installment. Like those would be 6-month installment loans, so that would be normal. I mean, it should be paid off in 6 months versus like a revolving, like one of these little credit builder cards that you get, where it's just open until you close it. So I would think that would have helped you, by having those for sure. Yeah, and what you're talking about, Stephen, I forget the names of them, but there's like some jewelry account or something where it's like, $5,000, $10,000. If you close that, then you lose all that available credit. But yeah, these 6-month things, that's exactly what you're supposed to do. So that's good. We need to have a bond only for certain collectors. Okay. Yeah, it's every state is different. And direct into my checking. Oh, okay. I think the loans went maybe into your checking or you paid it. Let's see. So I tell you what, we will end on this one. Any help for Texans? Well, this guy in the blue shirt is in Texas, so He is always willing to help a fellow Texan.
That's right, Fatima. So just reach out, Stephen at Stephen Palmieri, PALMIERI.com. Shoot me a message, and I'd love to talk with you for sure. So go ahead, take us in for the final stretch there, John.
Yeah. Well, listen, appreciate everybody being on here and spending your Thursday afternoon with us. We always enjoy the questions because Stephen and I enjoy chatting, but no more than like 5 minutes without outside questions. So we really appreciate you putting questions, comments, thoughts up, and we'll see you guys in a couple of weeks. So hope everybody has a great week.
Take care, guys.